Welcome to blacksnwhite.com. We're excited to have you here and dive into the world of knowledge. Let's learn something new and exciting together. Thanks for joining us. Have you ever found yourself struggling to answer difference between questions? Whether it's in an exam, an interview, or just a general discussion, knowing how to structure your answer properly is key. Today, we're going to learn the perfect structure to make your answers clear, concise, and impressive. And to illustrate this, we'll use a very important topic from the Indian Contract Act, 1872. The difference between an offer and an invitation to off. The right structure, what is it? The best way to answer any difference between question is to break it down into 4 simple parts. Definition. Start by defining both terms in a straightforward manner. Legal effect, consequence, explain the practical or legal outcome of each term. Examples, provide clear and well-known examples to support your points. Conclusion, table, end with a concise summary, ideally in a table format, to recap all the key differences. This structure not only makes your answer well organized but also demonstrates a deep understanding of the subject. Now, move straight to the main topic. Difference between offer and invitation to offer. Definition first, let's define both terms. Offer, proposal, as per Section 2 Clause of the Indian Contract Act, when one person signifies to another his willingness to do or abstain from doing something with a view to obtaining the other's assent, it is an offer. It shows a clear intention to be legally bound once accepted. Invitation to offer. An invitation to offer is not defined in the Act, but through judicial interpretation it means an action that invites others to make offers. The party making an invitation merely indicates a willingness to receive offers or to negotiate, without intention to be bound. Legal effect. Offer. When accepted, it becomes a binding agreement. Invitation to offer. Acceptance of an invitation does not create a contract, it only leads the other party to place an actual offer. Intention offer. There is a definite intention to create legal relations. Invitation to offer. The intention is only to attract proposals or start negotiations. Formation of contract offer. A contract is formed when the offeree gives unqualified acceptance. Invitation to offer. A contract is formed only when an offer made in response is subsequently accepted by the inviter. Examples make this distinction crystal clear. Offer example. Pharmaceutical Society of Great Britain v. Boots Cash Chemists, 1953. A customer picking goods from shelves and presenting them at the cash counter constitutes the customer's offer to buy. When the cashier approves and takes payment, it is acceptance. The shop displaying the goods is not making an offer but an invitation to offer. Invitation to offer examples. Display of goods with price tags. Price tags in a showroom merely invite customers to make an offer to purchase at that price. Advertisement of an auction. An auction notice is an invitation. A bid made by a participant is the actual offer. Menu card in a restaurant. The listed items and prices invite the customer to order, which constitutes an offer. Special case offer through advertisement. Carlill v. Carbolic Smoke Ball Co. 1893. Here the company advertised that it would pay £100 to anyone who used its product and still caught influenza. The court held this was a unilateral offer to the world, not merely an invitation, because there was a clear intention to be bound. Key distinctions table. Aspect, offer, invitation to offer. First, intention. Create legal obligation, invite offers or negotiations. Second, legal consequence. Becomes agreement on acceptance, no contract until an offer is made or accepted. Communication. Definite proposal, preliminary communication. Examples. Tender notice acceptance, Carlill, display of goods, auction catalogue, menu card. Conclusion. An offer is the starting point of a contract and binds the offerer once accepted, whereas an invitation to offer is only a preliminary step inviting negotiation. Recognizing this difference helps determine when a legally enforceable agreement actually comes into existence, a core principle in contract law. So, the next time you face a difference between question, remember to first define, second, explain the legal effect, third, provide examples, fourth, a table with conclusion. Thank you for watching this tutorial. We hope it was helpful. For more content, visit our website at www.blacksnwhite.com. Don't forget to subscribe to Blacks and White. Keep learning and stay safe.